Your lordships have dealt with this problem where the argument was there were prior leases. Your lordship said, sorry, post-accession, you have what the law gives you. You have nothing else. Now, if post-accession...
Actually, we need not really explore this line much for the reason that this might have impacts on other parts of the Constitution.
That's why, my lord, I was...
The Constitution which create rights in favor of specific groups.
Yeah, my lord, that is why I limited myself.
Whether they are based on religion, whether they are based on caste, on marginalization. So to say that by obliterating that right, you are not affected by a larger equality.
Malad, 370 operates.
If we accept it in that broad sweep.
No, Malad, that is why I'm saying 370.
Because I don't know what the ramifications.
No, Malad, 370 operates in a very narrow area. Very narrow area. It operates in the context of the compromise formula put in place for Jammu and Kashmir at the time of accession and at the time of its integration into India, etc., etc. And this power was kept to disapply. That's one provision, this special arrangement. Now, my lord, there is no equivalent in the Constitution. So we need to go, my lord, the Chief Justice is saying the danger in getting into constitutional propositions in one context and making broader observations, my lord, we don't know what you're trampling underfoot for the future. My limited submission was the principle of limiting delegation by statute, which comes from Article 14, can't apply. This radical change is a reading down of the power to extend laws.
That point you've made, Mr. Salve.
That's the only point which I was making. The second point I was making was...
Restricted to that level, there is no difficulty.
That's all. And the second point which I was making was, Bharat, that here abuse of power is really a power of competence.
And nobody's challenged the provision of clause 3 of Article 370. That is
which Malad, in fact, brings me
part of the original Constitution.
In fact, Malad, which brings me to my next point, and I'm going quickly now because your lordship has seen the point. That this repeated reference to basic structure, Malad, quite frankly, even in some of your lordship's judgments, I find a little surprising. Basic structure was not a principle as a independent standalone constitutional right. Basic structure is the limitation inherent in 368, and constitutional amendments are tested with reference to the basic structure doctrine. Well, there are some judgments which do say this law not only violates 14 but violates the basic structure. Laws, strictly speaking, if you don't
violate the basic structure.
Laws can't violate basic structure. Laws violate part 3 or don't violate part 3.
You know, in 2 judgments, though, we have said that a particular law protects the basic structure.
But laws are aligned with the basic structure.
The Places of Worship Act in Ayodhya, we said that is in pursuance of the...
Correct. But laws...
The second, we said that the amendment to the introduction of the amendment for Delhi,
yes,
239 AA, was in furtherance of the basic structure, which is...
furtherance of basic structure...
So there's a little bit of...
let me try and, in my very humble submission, when a law is made to protect civil liberties, 21 is a part of basic structure. A law made to protect civil liberties is a law aligned with Article 21 and therefore aligned with the basic structure. Now, one may in a flourish of language say it is to further. Today, if there are checks and safeguards built into arrest, checks and safeguards built into criminal trials, etc., etc., you may say this is to protect the basic structure, because the basic structure is the trilogy of rights. Now, that is not to say that the law was tested on basic structure.
That distinction you've made, yes, of course, because as a doctrine, it was evolved to test the validity of constitutional amendment.
The problem is, Malad, one thing is to say something is aligned or not aligned with the basic structure. But to say that an exercise of power under 370 can be tested on the basic structure doctrine, I submit is a misconception. 370 itself is a part of the original prestige constitution, and that confers the power to disapply the constitution, the arrangement. If I am right on competence.
Anything else, Mr. Salve, now?
So, that is the basic structure point.
Yes.
And the point which we have therefore already made, and I close with that submission, how would your lordship interpret this? the nature of the provision is such, if it confers plenary powers, not in the field of civil rights, not in the field protected by Part 3, but in the area of governance and in the area of constitutional adjustments, your lordship will give it the widest possible. Because the idea is never to hedge in future generations by reading the constitution narrowly, my lord. That is a well-settled principle. Last point which I have to make, my lord, is if we are wrong on this, the 356 test, can a change of permanence be made when a 356 regime is in place? It has two answers. I'll just take 2 minutes on this. This is no longer res integra, my lord. Your lordships have right from Rajasthan and Union of India, Bomai, chiseled this law and said, up to the stage where Parliament approves, don't do anything which is irreversible. Thereafter, you may. Because everything in one sense is irreversible. Man. What Parliament does is also irreversible. Parliament passes the budget for the states. It takes over the coffers of the state. What money is spent is irreversible. The money is gone. But that's the way it is. The president may not dismiss people, appoint people, create institutions, remove institutions. The governor may do, the president may do under 356. Those are for those people irreversible actions. That is why your lordship has said 356 is draconian and should be very sparingly used. If the unfortunate circumstances require that for a defined period of time, the system of governance is changed under 356, if those unfortunate circumstances exist, and a very narrow area of judicial review is permissible, it doesn't arise because there is no challenge before your lordship, a bald prayer without the necessary averments, then my lord, one is to accept the consequences of 356. But that's in the alternative. If I am right on my construction, my lord, of the proviso, quite frankly, minus the Constituent Assembly, it fell away. So you just added the state legislature and then you acted for the state legislature. Nothing dramatic really happened. If one ignores that also, if we are right on the proviso, then none of those questions arise. That, my lord, is the submission, unless there's something else I could assist your lordship.
And he says, subject to such exceptions and modifications as the president may order by order specify.
Yes.
There is a bifurcation.
Yes.
Matters which refer to the instrument of accession require consultation. Other matters, other than those governed by the instrument of accession, require concurrence.
Correct. Now, the point which I was making, perhaps that got lost.
We wanted you to just come back again. Yes.
So again, my lord, why this subtlety of instrument of accession being consultation and other than instrument of accession being concurrence, the significance should not be missed. Where it comes to instruments of accession and terms of accession, the last word is with the union.
No, where do you say that? How do you say that?
Because, my lord, instrument of accession requires consultation, not concurrence. The first proviso. Why this dichotomy in the first and second proviso, my lord? And that also, my lord, feeds into my point, therefore, that where it comes to disapplying the 370 completely, because the whole idea of 370 was accommodating the political compromise in the accession.
You know, Mr. Salve,
yes,
clause B of 371B,
yes,
does not relate to the power to make adaptations, modifications, or exceptions at all.
Yes.
What 371B says is that of all the items in the three lists, the president, the power of Parliament to make laws would be limited by specific matters.
Yes.
So you take the matters in the list as they are, and then you define what would be the domain of Parliament to make the law. There is no power to make exceptions or modifications in clause B at all.
No, not at all.
Bifurcates. You correctly said that there was a bifurcation. Matters which are referable to the instrument of accession are those on which you only require consultation, because these matters clearly specified in the IOA: defense,
correct,
foreign affairs, communication. Therefore, when Parliament specified the matters on which it would make laws, if those matters were referred to in the IOA, only consultation of the state government was required.
Yes.
because they were specified in black and white in the IOA.
Correct. But
Matters which were not specified in the IOA but are governed by the three lists, concurrence is required.
and my lord,
Now, when it comes to
yes.
D is not just specification of matters. D is making exceptions or modifications.
that's right.
There again, they had a dichotomy. You can make exceptions or modifications, but if it relates to matters in the IOA,
Consultation.
only consultation. So you are really right that insofar as D is concerned, in regard to matters which are specified in the IOA, only consultation is required.
And my lord, one cannot miss the significance, what I wanted to add, of the overlay of the principle of international law, which is engrafted in 363, that these are matters primarily for the sovereign. Instruments of accession and their interpretation has always been a matter for the sovereign. And here the accession being complete, irrevocable and irreversible. That is clear. 1 and 3, Article 1 and 3. Where it touched the instrument of accession, the president had the last word. And that philosophy is reflected in sub-article. That if you want to completely disapply this political arrangement, if there is a constituent assembly, consult them, otherwise you can do it. And there also recommendation.
In other words, Mr. Salve, what you are trying to drive at is that clause 3 of Article 370
Yes.
is absolutely on the same is on the same
Philosophy.
trend, or is the same platform
Yes.
as clause B1 and the first proviso to D. You are trying to equate the power and the substantive part of clause 3.
The underpinning is the same, my lord.
Power
The underpinning is the same.
The first proviso to D and B1.
Yes. And because the underpinning is, this is where we accommodated, or this is where the powers that be, when framing the constitution, accommodated the political compromise in Kashmir. And unsurprisingly, they reserved the power in the president. Instead of driving one to Article 368, they reserved the power in the president to disapply this entire. It's a very unusual provision, my lord. There is no other equivalent where the president is executive government, where the executive government can disapply a provision of the constitution.